Okay, in today's video I want to take a look at the role, the duties and the powers of an executor in the administration of estates. In other words, when somebody passes away and there's going to be an estate to be administered. What is an executor? An executor is the person appointed in a will to administer the estate of a deceased person. He or she is entitled and obliged to take out a grant of probate to the estate of the deceased. However, not all circumstances will give rise to a grant of probate being required to be taken out. In other words, if it's a very small estate with small money in it and no real property, then there may not be any need to take out a grant of probate. If you go to my website businessandlegal.ie, you'll see the circumstances under which it's actually not necessary to take out a grant of probate, but it is necessary if there's real property, in other words a house or a field or a site or something of that nature. And then there's a necessity if the assets in the estate are substantial as well, because banks won't release money out of accounts once it's over a certain limit. It varies from bank to bank, but once it's over a certain limit they won't release the money to an executor or an administrator without a grant of probate having been extracted. In an intestacy situation, then, an administrator is the correct title. So where there's a grant of probate and it's a testate estate, the deceased made a will, it's an executor who administers the estate, and in an intestacy situation where no will was made, the administrator is the correct title. And either one is known as the personal representative. So they are the personal representative in the administration of the estate, be it a testate or intestate estate. The role of the executor then, an executor needs to prove the will by extracting a grant of probate. And the powers and duties of the executor date from the date of the death of the deceased, with the whole estate devolving to the executor from that date. An executor does not have to act and may renounce, but once he or she takes on the role, he or she cannot renounce at a later date. The duties of an executor then involve ascertaining the precise value of the assets of the estate and protecting them. For example, it could be a house or a shop or whatever. This will involve ensuring that insurance, for example, is in place where appropriate. The executor must also ascertain all the liabilities of the estate, such as taxes, outstanding claims, outstanding debts, utility bills, and so forth. He also must ascertain all of the beneficiaries of the estate and check with those beneficiaries whether they have received any prior gifts or inheritances, because that will have tax implications. The executor must also prepare and swear an inland revenue affidavit. This will list all the assets and liabilities of the estate. It's a form called a CA24. It's quite a long form, it's quite involved, and you may need assistance with it. You can do it yourself certainly, but it is quite involved. The executor must lodge then all of the relevant documents with the probate office and extract a grant of probate. Once the grant issues, he or she will gather in all the assets and dispose of those not being given to the beneficiaries. The executor must also pay all of the debts and expenses of the estate, so this will include funeral expenses and so forth, must distribute the assets and must make sure that all of the taxes are paid, although it is really a matter for each beneficiary to take care of their own tax. Any taxes will include taxes due by the deceased prior to his or her death, and all taxes arising out of the administration of the estate itself. That's not so much of an issue now, because the probate tax and those types of tax have been done away with. Any inheritance taxes and capital gains then must really be dealt with by the beneficiaries themselves. But the executor needs to be careful that they're not left with any sort of a liability. So they would be, when they're sending out the money, quite frankly, to the beneficiaries, they'd be asking the beneficiary to sign an indemnity form indemnifying the executor against any claims for tax against the executor arising from the administration of the estate. The executor then must prepare an administration account, and he or she will account for all of the monies received and disbursed during the administration period. So this will be bringing in the various assets and the various amounts, the balances of the various accounts, if there is accounts, and then distributing them and accounting for everything. The powers of an executor then, there's statutory powers which come from the Succession Act of 1965, and extra powers can be given by the deceased in the will itself to the executor. Statutory powers would include things like the power to sell all or any part of the estate to pay debts, the power to act as a trustee for the purpose of the Settled Land Acts, the power to appropriate any part of the estate towards the satisfaction of any share in the estate, the power to appoint trustees for an infant beneficiary, the power to lease property, the power to mortgage, the power to settle claims and disputes. So they are all statutory powers that the executor has arising from or pursuant to the Succession Act 1965. The powers in the will may include the power to appropriate without serving any notices or consent, that's appropriate property in satisfaction of, for example, the legal right share of a spouse. The power could also be given to invest or purchase authorised securities. This might be with a view to maybe buying stocks and shares and holding money for infant beneficiaries or something of that nature. The power also could be granted in a will to employ agents or managers to manage an estate or manage property or whatever. If you are the personal representative, if you've been appointed a personal representative, if you've been appointed an executor in a will, or if you are trying to administer an estate where no will has been made, in other words, it's an intestacy situation, it's probably a good idea to get legal advice. My contact details are on the screen there, as you can see, and if you find this video useful, I would be obliged if you'd give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. I make a lot of videos about all aspects of Irish law, and I try to explain in plain language, plain understandable language, various aspects of Irish law, including property, probate, personal injuries, employment, small business, and so forth. As I say, I hope you find this useful. If you do, give it a thumbs up down below. Thank you.